Hi everybody, this is attorney Arkady Frekhtman. I'm a New York City personal injury trial attorney, and I wanted to make this quick video just to talk about depositions. A lot of people have depositions scheduled and they get nervous and they think like, what should I do in a deposition? Well, I think the number one thing to do is to, meet with your lawyer and prepare. Really, the lawyer should be preparing you at least 2 or 3 times, especially if it's a serious life-changing injury. If it's a big case, they should be preparing you 2 or 3 times, and far out, not the day before the deposition when you're all nervous and worried about how you're going to do, but far out, like maybe a month before, 3 weeks before you could have your first prep, then 2 weeks before a second prep, and like a few days before the third and final prep. And it's important to note that a lot of people get worried because they think, they're going to trick me, or they're going to show me a photo and say, hey, did you fall here? And if I say, yeah, I fell there, they're going to say, oh, that's not the real place. It doesn't really happen. People don't really do that. I've never really seen that happen. It's important just to relax and just be honest and look at the photo. If the photo shows where you fell, just say, look, that's where I fell. If the photo doesn't show where you fell, well, then don't say anything. You could just say, look, that's a real close-up. I'd have to see other photos. I need more context. Just, be honest. And also don't just go and start, talking and not knowing where you're going. And then you're like meandering through the woods and it's kind of like a stream of consciousness, right? What you want to do is listen to the question, understand the question, answer the question in your head without speaking. So if they're asking you, what color was the other vehicle involved in the accident? Think, well, what are they asking me? They're asking me the car that hit me, the car that, let's say, T-boned me. They're asking me only the color, right? Blue. Okay, I know it's blue. Now I'm going to answer blue. Because people get asked that question all the time. Let's say, what color was the other vehicle? And they say, oh, the other vehicle, that was a Chevy Malibu and he was driving so fast. But then they say, move to strike as non-responsive. And you know what? They're right, because they only asked you the color of the car. If you're talking about Chevy Malibu, that it was speeding, that it was being reckless, whatever. All this non-responsive stuff, all that gets stricken. So basically, then when the lawyer gets back to their office, they're going to write a report. They're going to say, well, this particular plaintiff was not a good witness because when I asked him questions, he or she did not answer the questions. They gave a lot of extraneous information. So to avoid that, just take a second. Like I said, just listen to the question, understand the question, answer the question in your mind without even speaking. And then when you know exactly what the question is trying to get from you and exactly what you want to say, at that point, go ahead and answer the question, right? Very, very simple. But for some reason, people can't do it. People don't do it. And so it could lead to a lot of issues. So I think that's very, very important, just to be able to answer the question. Then you have a clear record. And that's very good too, because remember, everything's being typed up by a stenographer. There's going to be almost like a book, your name, your address, what happened, where it happened, how it happened, what are your injuries. So it's important to listen to the question, to answer the question. Now, the only time where I think it's better to speak a little bit more is where they ask you questions like, well, how has this affected your life? Are you claiming loss of enjoyment of life? Tell me about that. There you could talk about everything, right? Your family, the things you enjoy doing, or what are some of the things you were able to do before this fall or this crash that you're no longer able to do. So there you can give a whole list of things. What are some of the things you can still do, but not as well as you could before? So you still do them, like I still sit in a chair, but now I sit in a chair with pain, right? So talk about that, because sometimes people will talk a lot about liability. They'll say, oh, that car was going so fast, blah, blah, blah. And they're trying to almost be an advocate and blame the other car, which is not so good, right? You don't want to be an advocate. You're the client. You just want to be a neutral witness, because if you appear to be like an advocate, people might think you're lying. You're trying to advocate for your side, right? You're not objective. So they talk a lot about liability, right? Fault. But then when the questions come down to, well, what can't you do? They just say 1 or 2 things, like I can't go roller skating anymore. Okay, well, that's it. And then that's not so good. So you want to be able to really tell the full story of what you truly can't do, because they're going to use that to evaluate how much of a settlement to give you. So if you just can't go roller skating, you say, okay, well, they can't go roller skating. Well, maybe, what's that worth? But they can do everything else under the sun. That's going to be really, really bad for your case. So you have to really think about what you really can't do and give the full picture. So I hope this was helpful. I mean, there's a lot of things we could talk about with respect to depositions, because depositions are basically like trial, right? In fact, a lot of lawyers say depositions are trial because most cases don't go to trial. Most cases settle. So the deposition is the only time that the defendant has an opportunity to listen to you, to see what kind of witness you are, to see if you're like humble, to see if you're going to start arguing, start interjecting, start giving non-responsive answers, right? See how your lawyer handles it. So it's a very interesting time, very important time. So it's important to do a prep. It's important for the witness to just be calm and to make sure that they get all their worries out during the prep. Sometimes in the prep, I'll just ask them, well, tell me about, what are you worried about? Instead of like prepping them, right, and telling them, this is what you got to look out for, this is going to be the question. Just listen to them, listen to your client. What are they worried about? Because they could have worries that are either conscious or even unconscious, subconscious worries. You have to listen to them. You have to make them feel at ease. That's very, very important. Once they're at ease, then they could just kind of let it flow, right, and be natural and answer the questions in a natural way, because everyone is different. Some people are more visual, some people are more mathematical or more numerical. So it's important to use their strengths. If people are more visual, perhaps they want to have some kind of visual aid to help them. If someone else is, or you could use visuals within prep. If people are more like numerical, they might want to keep like, receipts or something that will jog their memory. Now, in a deposition itself, now a lot of depositions are being done by Zoom, so you don't probably want to have like notes, or if you're going to a conference room, a physical conference room, you also don't want to bring notes, because then the defense lawyer could say, okay, I call for production, and you have to give over those notes. But you could definitely like have something like a diary or some notes that you review, just to have things in your mind, and then you keep everything somewhere else. Like you don't bring it to the deposition if it's in a conference room, but you could still review it even like 5 minutes before. And also, you don't have to really give any documents. If they say, do you have a driver's license? People start taking out their driver's license. Yeah, here it is. You don't have to do that. You could just say, yes, I have a driver's license. That's it. That answered the question. You don't have to give them your driver's license, because what they'll do is they'll take a photo of it, and then later they'll give it to their investigator and say, hey, go and videotape this person. They say they can't, carry a water bottle. Go follow them around and videotape them, carrying water bottles like in a Costco or whatever, or running, so you don't want them to know, to necessarily have that information. Like also, they might give it to their defense medical doctor, and then that defense medical doctor will say, okay, I identified them, have their license, and so yeah, you don't have to do that. So yeah, the important thing is just to keep the plaintiff calm, have the plaintiff be like knowledgeable, be calm, be like secure, and just kind of like answer the questions. And remember, there's usually not a trick, and if the defense lawyer is trying to trick or is trying to do something improper, then you can just make an objection. The lawyer should make an objection, and you could take a break. You can't take a break during a question. So if they say, hey, so what did we do wrong? You can't say like, I want a break. I want to speak with my lawyer because, there's a question pending. You have to answer the question, but then you could say, look, I need some time. I want to go to the bathroom, whatever, take a break. You could speak, you could consult, and then you go back on the record. So that's usually how it's done. A lot of the times they'll videotape depositions too, especially when we do defense depositions, when we question important witnesses. We like to videotape that because then you could play it at trial. So so I hope this has been helpful. Let us know what questions you have. We are here for you. If you have any questions about depositions, maybe depositions in a specific type of case, like a truck accident, car accident, slip and fall, construction, we could do videos about that. Or if you have a specific question about a deposition or specific issue that you are worried about, let us know, and we'd be happy to help. Okay, everyone, have a great day. We are here for you. Please like and subscribe to our channel, and stay safe out there. Okay, bye-bye.